Well, the normal questions when asked are when, who, and what. And the when is largely known. If it's not today, it looks like it's going to be tomorrow. The who, it's certainly going to be Donald Trump, but let me put a pin on that one. And the what is clearly going to be charges related to the events leading up to January 6th, but with a Georgia focus. But what I'm looking at is a couple of things that I think viewers should keep an eye out for, which is who else is going to be charged, either known names such as Rudy Giuliani, Sidney Powell, even Mark Meadows, as well as state electors. That's sort of an open issue. And why is that important? Because that will put additional pressure on them to cooperate. And that goes to the other thing that is the most important thing about these charges. A federal pardon does not affect these charges. So if Donald Trump wins the presidency or an ally, they have no ability to change these state charges. That also means that if there are a slew of conspirators who are charged by Fani Willis, they too cannot be federally pardoned. So there is a lot more pressure on them to cooperate because of these charges than at the federal level. And then the final point, Nicole, which may sound a little out of left field, is bail. Now, we have seen the former president get bail in Manhattan, in Florida, and in D.C. We have also seen the former president continue to make statements that, at least arguably, are obstruction of justice or intimidating witnesses. Why is that important? Because in Georgia, the statute that may apply here, depending on what is charged, is one where the presumption is one that the defendant has the burden of rebutting. In other words, it's on the defendant to show that he will not commit crimes, that he's not at risk of flight. And let me just give you the exact words, because this is the provision that the court has to find to release somebody on bail in Georgia, which is that the defendant poses no risk of intimidating witnesses or otherwise obstructing the administration of justice. That poses no risk of intimidating witnesses. To me, that is going to be, for a judge who is going to treat Donald Trump or anyone else like any other defendant, that could be a problem, because just today we saw a continuation of the attacks on the D.C. federal judge, and even Truth Social saying that Jeff Duncan, the former lieutenant governor, should not comply with a grand jury subpoena in Georgia. You can't tell a witness not to comply with a grand jury subpoena unless there's some legal ability to do that. But that's not what the former president did. So it'll be interesting to see how the judge deals with bail as we go forward.
Well, Andrew, let me put you out on that, because as you just pointed out, witness intimidation is his brand. It's what he does. I don't think he would deny that. It's what he has got his TV lawyers out there on the shows arguing he has a right to do as a candidate for president, whether it's Mike Pence or Jeff Duncan or others. I mean, are you saying that there could be a clash as early as right away?
Yes, absolutely. Now, I know a lot of people, including myself, are thinking, how could somebody who's running for president be thrown in jail pending trial? But remember, you can run for president without intimidating witnesses. So if you make the choice to intimidate witnesses, I know this is incredible that we're having this conversation, Nicole.
It's amazing. Yeah.
So it really isn't a clash. You want to run for president? Absolutely. But the statute, and this is what Judge Chutkan was saying, which is, you do what you want to do to run for president, but I've got a criminal case to run, and that takes precedence. So if the law is in Georgia that the defendant has to establish to a judge that he opposes no risk of intimidating witnesses, no risk of intimidating witnesses or otherwise obstructing justice, that is a tough hurdle. And I'm not saying that a judge is going to throw him in, but that is the legal standard. And it'll be interesting to see how lawyers for Donald Trump are going to seek to do that when he has actually said, if you come after me, I'll come after you. And even after the day after admonitions two admonitions in federal court in D.C., has continued to, as you said, Nicole, engage in what he does, his MO, which is intimidation and fear, which he's doing for obvious reasons.
Harry Lippman, the comparisons to a mobster can be overwrought. But in terms of this friction of a target, in this case, he'll be indicted again, a charged target, and the system, I don't know that there's any more apt comparison. And I wonder what you're watching.
There is no more apt comparison, but Andrew's point is one of a welter of different issues where you read the letter of the law, and the letter of the law points strongly against him. Burdens of proof, it sounds legally arcane, but think of being John Laurel having to stand up and make the case. There is no risk of witness intimidation. It's virtually impossible. Now, it'll be a very important point in the first instance whether the prosecution, whether Willis's office will seek pretrial detention. I'm like Andrew, it's impossible to think that would happen, and yet the letter of the law seems to point strongly toward it. We're playing this out in many different contexts in which we want to treat Trump like any other defendant, but certainly in certain contexts that seems to dictate all kinds of consequences, including going, into jail now awaiting trial. I just want to underscore one thing. I think that to Andrew's point, slew is the operative word here. What we're going to get that's really in contrast from what we've seen in the three other cases is all the president's men and women. 18 people have been notified their targets here. Some of them have sought and received immunity. But we're going to get it's not just the pressure, but a wealth of information, as we just found out about, say, in Coffee County, that has been missing to date from the various indictments we've had, which really will be just a huge conspiracy involving many people to the top. And that matters in the law, but it also will matter in the facts. We're going to learn a ton in what I expect will be up to a 100-page talking indictment from Fani Willis.
I want to pull back the curtain on some reporting we're trying to run down. NBC News has just learned that Judge Robert McBurney has advised reporters present in his courtroom to, quote, go get dinner. He advised the courtroom deputy to get his cell phone number from his assistant because his assistant is leaving at 5 p.m. It's in about 50 minutes. This means the courtroom deputy will be calling the judge directly to alert him if and when there are indictments he needs to preside over. The judge told the press that other regular business is finished for the day, and the courtroom deputy in the room told reporters that the judge is keeping the courtroom open until the district attorney's office tells him otherwise. We're working on getting one of our correspondents who's on the ground there up to just sort of flesh that out for us. But Harry Lippman, what does that sound like? Get dinner doesn't mean go home and go to bed.
McBurney's a straight shooter. He's the guy who's the chief judge who we saw issue some very thoughtful opinions. He's cutting him a break. He's saying, I know why you're here. You can go get dinner. It doesn't mean exactly it couldn't happen tonight, but it certainly seems to point in that direction. Won't be for a couple hours. The one contraindication, we've been looking at Tuesday at the earliest, but it's really a striking fact that two people who were going to come on Tuesday